our calendar this morning for the motion to enforce. You got somebody else on the phone? Being available and tentative this morning, to both parties. Mr. Moss, did you get a chance to review it?
I have, Your Honor.
Mr. McNeley, did you get a chance to review it as well?
I haven't read it yet, but I have a courtesy copy of my documents I want to give to you.
Is that the Medicare documents?
No, this is actually the opposition against their murder.
Okay.
So this is a courtesy copy, by the way.
Mr. Moss, do you wish to be heard on the defense motions?
Actually, no,
Did you get a chance to review the opposition?
I did, Your Honor. Excuse me. Mr. McNeley, is there a reason why you didn't file this earlier instead of filing it in the morning when I call the calendar?
The last hearing that you had with me, you specifically told the defendants to give notice. Okay, I was waiting on notice. I never received notice. That's why on the front of this page at the bottom, it says defendant McDonald counsel failed to give notice.
I see that on the bottom of the first page.
First page where it says that all parties in
I see.
the attorney will record.
I see.
Okay, in the last hearing, you gave the wrong date. You said 8/14. I had to call the court and find out the correct date.
So my let's see, Mr. McNeley, you transcribed that that unlawfully recorded conversation. Let's see.
Oh, could you repeat that?
I see you transcribed the unauthorized recording of the court proceeding.
Yeah, that's been filed in the court several times already. I'm surprised you're just now noticing that.
Well,
That confirms my theory that you had not been reading my paperwork.
very well. And you saw the court's response to your unauthorized recording as well.
Yeah, and I also
Which resulted in an order being issued from the court banning future efforts to do such unapproved actions.
I also requested an evidentiary hearing which you never addressed. Did you see that exhibit where I requested evidentiary hearing? And you
Mr. McNeil, I said, once again, one moment, please. If I am to review what you just handed me, I need an opportunity to read it. All right, Mr. Moss, do you wish to be heard on this document that Mr. McNeil apparently followed the court last week?
Other than to the extent that
It hasn't populated in our system yet.
I couldn't find it. I did receive notice of it Saturday night, and I couldn't really make out exactly what it was arguing, so I really don't have a lot of response.
Since he's talking about a number of things that's not before the court today, I would agree.
The agreement is before the court today, from my understanding.
Yes, the motion to enforce the settlement agreement is before the court as well as the motion which is sealed. So is there a part of the tentative that was handed to you, Mr. McNeely, that you'd like to address?
I didn't get into it to read it, but I do know as far as the agreement goes, he changed the wording in there, and he
has not stated the entire agreement in open court. He didn't state the entire agreement. Therefore, so the judge would know what's in the agreement, I would know what's in the agreement, and therefore we all have a meeting of the mind. So therefore, he has not clearly recited this agreement in open court.
Your Honor, the court stated the agreement in open court and well documented in its minute order, which is reflected in our release that we provided to the court as well.
And my rebuttal to that, Your Honor, is on November 5th, your minute order says that the monies will be paid to the plaintiff. The defendant went back to his office and wrote the written agreement up saying the monies will be paid to the Medi-Cal. And from what his partner's telling me, Edwin Sasaki, what he's telling me is that if...
Put your mask on, sir.
Well, I want to make sure you can hear me clearly.
I can hear you.
So what Edwin is telling me is that if there's no lien against the case, the money goes to the plaintiff. And so I was in agreement with that because this has already been put on my credit, and therefore I can go to the creditors and see if they would take a lower price or whatever and kill this and get it off my credit. But if the money goes to Medi-Cal, then there's no negotiation for me to go to the creditors to negotiate. But he does have in there that you're responsible for all bills and all liens and everything.
Yeah, I'm not sure if you're talking about the creditor being Medicare or if there's some other creditor. I know that Medicare, should they have a lien, would need to be paid some money out of this amount. I just don't know how to calculate that.
There is no lien from Medi-Cal.
Medi-Cal or Medicare?
Medi-Cal, there's no lien from them. This is for the hospital in Long Beach. Long Beach Hospital is the one who put this on my credit saying they didn't get paid because Medi-Cal rejected the paperwork.
I have requested many times to have a call and authority to call and negotiate on behalf of the plaintiff, but he's disregarded my offers.
I didn't disregard your offer. And this is why I put in my objective, so that's why I put in my rebuttal that the plaintiff was unable to agree or understand the agreement.
Mr. Ross, without a lien, cost of money, which is what the court is asking for to disperse it.
Yes, Your Honor, I would, absolutely. If I would make that, I guess, to the clerk of the court, which would be positive of the court.
And because then I'm not aware of any lien.
Yeah, I'm not aware of it. If he's representing that there's no Medicare or Medi-Cal lien, I would want to go back, I guess, and just double check that because I was under the impression that there was some Medicare that addressed something.
I've always told you, Long Beach Memorial, where I went and had been looked at and was looked at by the doctors, and I put bills in here, I put bills in all my paperwork showing you who this stuff is coming from. There's bills right here. It says Long Beach Memorial. I always told you, go back and look at the heading of the paperwork. You're like, oh no, that's too much for me. I can't do that. Send me something. I'm like, dude, I've been putting it in my paperwork since 2017. We're in 2021.
Sir, Mr. McNeley, you can address the court, please. Mr. McNeley, we have your mailing address as P.O. Box 93, Inglewood, 903, Phillips. That's still current?
That is correct.
Okay. So, Mr. Moss, without any indication if there's a lien, is there a reason why you're asking for the payment as opposed to your firm?
I'm sorry, that I would forward the money to him? Or no, I have no problem sending him a check. I've wanted to do that for a while until the settlement. I guess if the court signs the settlement agreement, I could then forward the payment to the plaintiff directly.
I'd like to add something else, Your Honor.
Certainly, Mr. McNelly.
On the vexatious litigant piece, I did catch that in your paperwork. On the vexatious litigant, it says that in order for a person to be a vexatious litigant, he has to have 5 cases that are frivolous and harassing in nature. I looked through the record all over for the last month, looking through the whole record. I have not found a list that the defendant has filed. An adequate review says that the defendant is supposed to present the court with an adequate review of the record, showing that the plaintiff was a vexatious litigant.
Mr. McNelly, that's not before the court.
Huh? No, you mentioned it in your order, so I thought I'd bring it up because I need to know where is it in the record that the defendant filed an adequate record for review, so I can find it. I can't find it. Can somebody cite to me where it is in the court record so I can be on point? Because you have to have that in order to grant that. And from what I see, you granted that, and they have not presented an adequate record for review. I put in there all the attorneys that represented me.
Your Honor, Mr. McNelly appealed that to the appeals court, and that appeals court.
I understand it.
Yeah, I understand that. That's a void judgment. I can go back and redo that at any time in any court because it's a void judgment based on the fact that you have not submitted evidence in the court records to prove what you claim. So that's why I'm asking for adequate. That's why I'm asking for where is it in the court record where he can cite to me where I can go see where he submitted an adequate record for review because I can't find it.
Well, it's in your book of papers.
Yes.
Right. Mr. Moss, do you see an issue if I modify this tentative for you to reaffirm before the payment to Mr. McNeil?
Not at all. We will send the address. We will send payment directly to the address the court just received.
Right. The court appoints the clerk has indicated to sign the release and confidentiality agreement on plaintiff's behalf in order to pay it to. I'll modify this to forward the settlement payment to Mr. McNeely as opposed to the court within 10 days of today's date. Is that acceptable?
Yes, sir.
All right. In all other respects, the tentative is adopted as the court's will. All right. Thank you. Present the invoice, please.
So I'm not going to get the citing where it is in the court record, Your Honor.
Mr. McNeil, I've already indicated where it is.
I know I didn't hear where it is. Can you tell me where it is? Because I didn't hear that.
Thank you.
So that's it. You're just going to leave me hanging?
Mr. McNeil, it's in the moving papers.
Thank you, Your Honor.
McDonald.
It's not in there, and you need that in order to grant the motion. So therefore, you didn't have that, and you granted the motion, and that's why it's void.
Well, that would be a problem. I would agree with you on that, but it wasn't in the moving papers.
It's not in the moving papers. I'm telling you, I looked in there. I went through the whole thing. That's why I'm bringing it up today. They don't have no evidence to support that motion. That's why I told you that I believe he was being biased.